Bonjour et bienvenue. Hello and welcome. I am Oonagh Fitzgerald, President of the International Law Association of Canada, and Senior Fellow with the Human Rights Research and Education Center and Visiting Professor at the University of Ottawa. I'm excited to be moderating this incredible panel of experts discussing international law and anti-corruption measures, droit international et lutte contre la corruption. In keeping with Indigenous protocol and building respectful relationships between Indigenous and non-Indigenous peoples of Canada, let me begin by acknowledging the traditional territories of Indigenous peoples. We are meeting virtually across Canada and well beyond, so I would like to acknowledge that the Indigenous peoples are the original occupiers, traditional stewards, and inherent protectors of the lands and waters called Canada today. Nous sommes reconnaissants de vivre, d'apprendre de cette terre et d'en profiter, et nous nous engageons à la décolonisation dans nos vies personnelles, nos entreprises, nos organisations, nos écoles et dans nos communautés. Les engagements que nous prenons dans cette reconnaissance des terres doivent être activement poursuivis et s'accompagnent de la conviction que la décolonisation commence par la réconciliation avec tous les peuples autochtones, y compris les Premières Nations, les Inuits et les Métis. If reconciliation is to be successful, we must continue to deepen the ways in which we listen to, learn from, and support Indigenous peoples and their resilience, resistance, and self-determination. Let me tell you a little bit about the International Law Association. L'Association de droit international du Canada est la branche canadienne de l'Association de droit international basée à Londres, en Angleterre, et fondée à Bruxelles, en Belgique, en 1873. Avec plus de 4500 membres dans le monde entier, notre objectif collectif est de promouvoir l'étude, la clarification et le développement du droit international, tant public que privé, et la promotion de la compréhension internationale et du respect du droit international. Nos membres sont mondiaux et diversifiés, et nos membres fournissent une gamme complète de services de droit international aux acteurs étatiques et non étatiques qui façonnent notre contexte socio-économique, environnemental et politique actuel. Comprised of legal scholars, legal practitioners, students, and policymakers, the ILA Global Network and its regional and national branches contribute to the work of ILA research committees on important topics of international law. This year, we were pleased to assist in hosting two ILA committees meetings, Business and Human Rights in Montreal in May, and International Monetary Law in Toronto in September. ILA holds biennial conferences. The last one was in Athens in 2024, and the next one is in Vienna, Austria, in 2026. The ILA organizes panels and workshops on a wide range of international law topics, such as this one. I invite you to visit our website and join ILA Canada. Membership is free for students as part of our effort to renew and replenish this valuable global network of international lawyers. Now, just a little bit of logistics. You're invited to put your questions in the Zoom Q&A function. Please feel free to pose questions in English or French. Vous êtes invité à poser vos questions dans la fonction de questions et réponses Zoom, en anglais ou en français. And I'd just like to mention that Dr. Leonardo Borlini will not be able to stay till the end of the presentation. So if you have any questions for him, I suggest you get them ready in the next few minutes because he'll be our second speaker and he'll have a few minutes afterwards to respond to your questions. Okay, so today, leading global experts in the fight against corruption will explain the state of domestic and international law addressing corruption, the challenges of enforcing anti-corruption laws, and promising approaches to filling governance, information, and enforcement gaps. The exceptional panelists presented today will discuss the international and domestic criminal law dimensions of corruption and anti-corruption efforts, internal corporate culture issues affecting corruption and corporate governance measures to mitigate corruption risks, the challenge of asset recovery in multi-jurisdictional economic crime and international serious fraud, the key pillars of the proposal for an international anti-corruption court, the role of the proposed asset division in criminal and civil cases, and UN anti-corruption priorities and efforts. It is my honor to introduce our distinguished panelists, each of whom has extensive relevant experience in aspects of the fight against corruption. Our first speaker will be Dr. Jennifer Quaid. She's a full professor, civil law section, Faculty of Law, University of Ottawa, teaching criminal law, competition law, and corporate law. She's an internationally recognized leading legal expert and scholar in the fields of organizational criminal liability, corporate accountability, competition, and business regulation. A member of the bars of Quebec, Ontario, and New York, Professor Quaid practiced law for several years, first with the Federal Department of Justice in Canada and then in private practice for a leading New York firm. Second, we have Dr. Leonardo Borlini. He is a full professor of international law at the School of Law at the University of Bocconi, where he teaches courses on international and European law and dispute resolution in a globalized world. He is lead expert for the United Nations Development Program, Global Program Governance for People and Planet, or G4PP, called Compliance and Effectiveness of Global Anti-Corruption Measures, Norms, and Standards. Third, we have Martin Kenney. He is founder and head of a British Virgin Isles law firm, MKS Law, focused on fraud and asset recovery. He is one of the world's leading asset recovery lawyers, specializing in multi-jurisdictional economic crime and international serious fraud. A practicing solicitor advocate of the senior courts of England and Wales and the Eastern Caribbean, and a licensed foreign legal consultant in the state of New York, Martin has acted for international banks, insurance companies, individual investors, and other private and governmental institutions. Then we have Dr. Juanita Olaya Garcia of IMPACTOOLS. She is an advisor to international and national institutions, citizens, and communities on issues of integrity and human rights. Founder of the United Nations Convention Against Corruption Coalition Victims of Corruption Working Group, her specialty lies at the intersection between law and society. Fourth, we have the Honorable Allan Michael Rock, King's Counsel, who is President Emeritus of the University of Ottawa and a former professor of law in its Faculty of Law. Elected to the Canadian Parliament in 1993, 97, and 2000, he served for that decade as a senior minister in the government of then Prime Minister Jean Chrétien in both social and economic portfolios, including as Minister of Justice and Attorney General of Canada. He was appointed in 2003 as Canadian Ambassador to the United Nations in New York, and in 2005 led the successful Canadian effort to secure unanimous adoption by the UN members of the responsibility to protect. And last but not least, we have Professor Robert J. Currie, King's Counsel, who is a full professor at Viscount Bennett, Professor of Law at the Faculty of Law, University of Dalhousie. He is a specialist in the area of international and transnational criminal law, and his acclaimed book on the subject, International and Transnational Criminal Law, is now in its 4th edition and has been cited by the Supreme Court of Canada. He is a qualified barrister and appears in court as both counsel and as an expert witness in cross-border crime cases. He is also regularly invited to participate in continuing legal education for both the judiciary and the practicing bar in Canada. So there you have the amazing panelists that will be presenting to you today. And let's begin now with Jennifer Quaid, who will be introducing us to the issue of corruption, ordinary and grand, from the angle of Canadian domestic legal system, connections with anti-terrorism and money laundering, and linkages to transnational crimes and investigations, etc. Over to you, Jennifer. And you're on mute right now. There you go.
Thank you, Oonagh, for that wonderful introduction, and thank you for organizing this event. It's always a pleasure to join in these activities and these conversations, which are really important. I'm going to share my screen. I have a few slides which will help guide the conversation. So if you'll just bear with me for a second, I will put those up, and I'm going to also start playing from the beginning. Does everyone see my slides?
Yes,
I'm
perfect.
assuming yes. Okay. So unlike pretty much everyone else on this panel, I am not an international lawyer, and I would never hold myself out to be one. I am a solidly domestic lawyer. But I do think in order to launch this conversation, particularly for those of us who are joining us in Canada, although I appreciate that there may be an audience outside of Canada as well, I think it helps to start with what we do here. Then we can understand what kind of role international efforts have and can play in support of nationally based efforts. So this is a conversation that's designed to give you some grounding in what's done in Canada. So I'm going to talk about 4 basic things in very, very broad strokes overview. And if there are questions, either after the presentation or during the discussion, please feel free to ask them. Et je tiens à souligner, vous pouvez poser vos questions en français, il n'y a pas de problème. Ça me ferait plaisir de vous répondre en français. The slides are in English just for simplicity. So I'm going to talk a little bit about what are the laws in the books, what's the policy framework at the federal level. One of the things that people need to appreciate is that Canada is a federation, and there is a division of legislative responsibility that does affect corruption, and I will touch upon that a little bit. I'm going to talk a little bit about who the players are around the table at the federal level, because it's impressive. And then I'm going to talk a little bit about anti-corruption enforcement and some other related policy measures. And then I'm going to close with just a few comments on some external assessments of Canada's performance by 2 international based entities. And woven in there, I will talk a little bit about the connections between anti-corruption enforcement and other areas of economic crime that are certainly preoccupations at the moment from a policy perspective. So in terms of corruption in Canada and talking about anti-corruption law, you have to make a broad distinction between what I would call domestic corruption. It's not called that in the criminal code, but that is essentially what it is, and foreign corruption. So domestic corruption is basically covered by a series of offenses in the Criminal Code of Canada, and also one complementary offense in the Competition Act, at least in my opinion. That sort of covers the basic broad strokes of the kind of conduct that could be characterized as corruption or associated with corruption. So there is corruption itself, fraud, money laundering, proceeds of crime, financing of terrorism. There are a bunch of different angles, and there are different offenses in the criminal code. Well, I think what's important to underscore is there are different ways of resolving these cases, and in particular, I want to highlight the addition of Part 22.1 of the Criminal Code, which is what created the Canadian version of a deferred prosecution agreement. It's called a remediation agreement, or RA. And the other thing to note, which is very important for our foreign guests and audience, is that prosecutions under the Criminal Code of Canada are handled by provincial prosecution services. There is a shared jurisdiction in fraud, and foreign corruption is handled by federal prosecutors. But it's very important to keep that in mind. Under the Competition Act, it's federal prosecutors who handle those cases, and I just highlight that bid rigging is a distinct offense under the Competition Act. And there are different resolution techniques under the Competition Act because those offenses are not covered under the eligible offenses for our form of DPA. For foreign corruption, we have sort of the signature statute, which is the Corruption of Foreign Public Officials Act, the CFPOA, which sometimes people get tongue-tied thinking FCPA, which is the US statute. There are 3 key offenses in there, sections 3A and 3B, each a distinct offense, and section 4, which is an accounting offense. They're all serious criminal offenses, indictable, maximum 14 years imprisonment, and fines that are not determined, which essentially means that they are in the discretion of the court. These prosecutions are handled by the Public Prosecution Service of Canada, which is the federal prosecution service. I think it's helpful for people to understand, because there is quite a bit of talk about how there isn't enough enforcement in Canada and there isn't enough evidence of effort being put into particularly anti-corruption or corruption-based prosecutions. And I want to highlight what is on the plate of prosecutors when they have to prove this offense. And I'm focusing on foreign corruption because our conversation is about, international efforts. And I think this is where perhaps there are more connections to be made. The standard's very high in Canada, and this is sort of the fruit of a couple of decided cases. And we really do not have that many decided cases that go into detail about foreign corruption. But on the actus reus, you essentially have 4 elements you have to prove, or for those who might be more familiar with the term, material elements of the offense. You have to show that the accused gives a direct or indirect benefit, that it was made to a public official or someone else on behalf of that public official. The benefit had to be offered in order to obtain an advantage in the course of business. So this is about business advantages. And finally, there has to be a quid pro quo. The offer of the benefit, is in consideration for what the public official is supposed to do. This is important because this is part of the first offense, paragraph 3.1a. 3.1b actually talks about attempts to induce foreign officials to give an advantage. And there you don't actually have to prove the quid pro quo, but we do not have a deep case law to confirm absolutely that there isn't other elements. But that sort of gives you a picture of what has to be proven beyond a reasonable doubt. On the mens rea, the key mens rea, I haven't gone into all of them because each actus reus, of course, needs to be proven with a corresponding mens rea. But the main one here is about who you're dealing with. The accused has to either know or be willfully blind, which really means you're closing your eyes to something you should check and ask a question about. This is not negligence. This is you're choosing not to know that the benefit or the advantage is being conferred to someone who has the characteristics of a public official. There have been some cases where, in fact, the person who is making the gestures is confused about whether or not this person is a public official, and that can be a problem for the prosecution to prove. So one of the issues is actually making sure that you can establish that the accused knew what they were doing and they knew who they were dealing with. So that's an important point. Now I think I'm going to move on to the institutional framework, just in the interest of time. So here I want to show you, just to give you a picture of who's around the table. So this is from the last annual report to Parliament on the implementation of the OECD Convention in Canada, and it's done every year. Basically, reports from September to September. So we're waiting for the 2025 report. But you can see there are a lot of federal departments involved here, and that's not even talking about provincial involvement, which can be relevant in some cases. So we're talking about tax authorities and commercial and export authorities, the Competition Bureau, several key departments, finance, justice. There's also public prosecution service, public services and procurement, the Royal Canadian Mounted Police, Treasury Board. So you can see there's global affairs, many departments involved. You can foresee that there are sometimes some coordination issues. Some other things that I think are important to mention, because they're not legislative per se, there has been for many years a policy on public procurement at the federal level. There are also equivalents at the provincial level, which I will give you a small taste of in a minute. The Office of Supplier Integrity and Compliance is a new thing to replace the old integrity regime that existed, and essentially it's set up. I'll talk about it in a minute, but it's set up to be a new way of establishing whether suppliers are ethical and worthy of getting public contracts. It used to be a debarment system. Now it's more like a weighing of factors. There are some other complementary measures that have been done, that are related. Again, I talk about related to corruption. So implementation and fighting against forced labor and child labor and supply chains. We know that, human rights abuses and other gross violations of obligations under international law can be a source of corruption or a source of impetus for corruption. So that's important. This is reporting. We have FinTrack, which is really about record keeping, identifying clients, and reporting requirements for suspicious transactions, because of course that's how corruption can be, successful, is that we can launder the proceeds later. There is a new unit that was just created in the spring called the Financial Crime Coordination Center, and there's the Canadian Anti-Fraud Center. I'm not going to talk about sanctions and asset seizure, in part because I don't know it very well, and also because Professor Currie is going to talk about that. And I signal, just because there are many lawyers probably on this call, that there is also an effort by the part of the Federation of Law Societies of Canada and provincial law societies to deal with how lawyers fit into this policy, because following a Supreme Court decision in 2015, they are not actually subject to these reporting and other requirements. And yet, of course, they are key actors in the ecosystem. Moving right along, a couple of provincial measures that might be useful to know about. That Quebec has probably been the most forward on these things, followed by British Columbia, because they both had to deal with, I guess, investigations into things that were happening, and that really brought it to the surface. So in Quebec, the Charbonneau Commission, and in BC, the Cullen Commission. But Quebec actually has an authority that oversees what it calls public markets. So it's oversights of public procurement and eligibility of businesses to tender. They have actually a municipal version for the city of Montreal. And in beneficial ownership, which is knowing who ultimately owns interests in business, both Quebec and BC have been ahead of the curve. There's also a federal registry. So a little bit about the enforcement record and some policy measures. Oops, sorry, I went too fast. The enforcement record is dismal, but I want you to keep in mind the requirements that prosecutors face concretely. So there have been rare convictions in individual cases, and there are some that are in the pipeline that we don't know what's going to happen, that are associated with the remediation agreements that have been that have been concluded. I note for businesses and corporations, the resolution techniques that exist, remediation agreements in particular. The one example we have in foreign corruption is Ultra Electronics from 2023. There are traditional plea bargains for companies. Those are the older cases, Watts, Griffith, Nico Resources. And then there is the SNC-Lavalin Libya corruption plea deal, where a subsidiary pled guilty for the parent. That was an interesting structure, and if anyone wants to know more about that, I'm happy to talk about it. There are some high-profile acquittals, including Arapakokta and Bara and Govindia, which appear to have been abandoned. A mistrial was declared, and they were never taken up again. But Mr. Arapakokta was, in fact, acquitted. There are other cases, unfortunately, that were discontinued due to either delay, and Canadians will know that, that refers to the Jordan decision on the trial within a reasonable time, or there are evidentiary problems. And this is not uncommon in these cases, which take a long time to put together. Oh, I skipped over my policy measures. So just a brief comment on the Office of Integrity Commissioner. This is just a highlight. It's by no means meant to be complete. This new office has a system where they will determine whether companies need to be suspended or ineligible because they have been found guilty or pled guilty to a certain number of listed offenses, which include corruption, but it's much wider than that and can include labor violations, human rights abuses, environmental abuses. So just to keep that in mind. It's basically like a sentencing process now, where you weigh mitigating and aggravating factors, and then the integrity commissioner makes a determination of what kind of arrangement is suitable. And I will insert a small editorial comment here. One of my worries is we are in the cusp of a huge amount of public spending, and spending in strategic sectors where there may not always be a large choice of suppliers. And I am worried about exceptions being made because we just need them. Those exceptions have always existed, but I think there's going to be more pressure to overlook past mistakes. At present, there are only 5 companies that are ineligible, and one of them, for some people may remember, a well-known plea bargain, Canada Bread Company. It was the bread price fixing, and they are listed there. So final couple of words. I'm going quickly because there are 6 other panelists. Just some external assessments of Canada's regime. I'm going to start, it's just a quote, and I don't expect you to read it, but essentially this is from the OECD Phase 4 evaluation, which occurred in the spring and summer of 2023. The report was issued in October 2023. And, you know, in a nutshell, here are the takeaways. They note the progress on legislative tools. Canada's very good at enacting legislation and producing written documents, but there's enforcement guidance that could be developed, and as compared to other jurisdictions with, for example, deferred prosecution agreements, we really have very little in the form of guidance. There's a lot that has been developed by prosecutors on the fly, and prosecutors don't necessarily mind that, but from a public information and transparency perspective, it's not ideal. There is, as I think I explained, low prosecution and enforcement rates, and there is a note that resources need to be improved and increased. And one of the considerations is, staffing at the RCMP and retaining those very specialized investigators, and not removing their budgets when times are tough. We are systematically called out for weak whistleblower protection. And the other, really big weakness is transparency in data collection. There just isn't a way for the public to really know what's going on. My students are always astonished at how amazing the Serious Fraud Office website is compared. There's just nothing equivalent here. You can't go on to global affairs, to justice, to public safety and get some sort of central point where you can find out information on anti-corruption efforts. And part of that's because it's divided between federal and provincial prosecutions, but nevertheless. And the other thing is that even internally, when we're talking about confidential information, there should be better tracking and internal data collection and analysis. And finally, there is some suggestion, and I will admit that that came in part from Transparency International Canada, which I'm a member of the legal committee, about exploring other ways of enforcing corruption than strictly through a strict, subjective mens rea offense with all the bells and whistles, and perhaps a failure to prevent corruption. More of a compliance type offense that might be structured as a regulatory strict liability offense could be better. And finally, we are currently under review by the FATF, so the Financial Action Task Force. The key element, and I apologize for the typos I typed quickly here, is we're good at technical compliance, but can we actually sort of demonstrate effective action on anti-money laundering and anti-terrorist financing? And there really is, a question about how we handle legal professionals. And the Law Society will have a particular position on that, and I'm not going to get into that debate, but just so you know. So I'm sorry that was very quick, but that's basically laying the table for how Canada is positioned domestically. And, one of the questions we have is we have all these tools, but for example, we haven't really been part of a multi-jurisdictional settlement like the Airbus settlement. We don't seem to be at the table for some of these discussions, or at least not visibly. And what's happening behind the scenes is not always visible to the public. There is a lot of cooperation and collaboration informally, but how do we take it to the next level? So without further ado, I'm going to leave it to the next speaker, and I will stop sharing my screen.
Jennifer, thank you so much for that really helpful presentation. Now we'll turn to Leonardo Borlini, who will speak about, as the UN specialized expert on corruption, and he'll provide an empirical analysis of the implementation of key international anti-corruption treaties. And as I mentioned, please be sure to have your questions ready. So if you want any answers from Leonardo. Thank you.
Thank you very much, Oonagh, for the introduction and for the clarification on my possibility to not sticking around for long. And thank you also, Jennifer, for having set in the scene so well. Actually, some of the hopefully contributions to the discussion I will bring to the table are kind of related to your key takeaways regarding Canada and regarding the OECD report. What I'm trying to present today, and I will try to stick to the time allocated, which is 15 minutes, is the work that I've carried out for the United Nations Development Program as the lead expert of one of the section of the measuring corruption and anti-corruption efforts in, of course, comparative way, meaning trying to assess this framework. In my case, the assessment of anti-corruption efforts, at least of the major core of countries which are parties to the United Nations Convention Against Corruption. I actually completed my mandate in August, so now I'm kind of you know, I just speak out of my capacity as a professor of international law, but I will stick to the work I have conducted for UNODP and also for UNODC as a lead expert. My lead reviewer was Drago Kos. I mean, the lead reviewer of the project was Drago Kos. Excuse me, who was former chair of the OECD Working Group on Bribery and formerly chair of the Council of Europe Group of State Against Corruption. So what we tried to do, or the goals we had when we were chosen by UNODP, was to define a methodology that permits to measure both technical compliance and effectiveness as the two complementary elements of the main anti-corruption treaties implementation. As you know, also because Jennifer mentioned the FAFT assessment process, you can actually divide it the successes or achievements, and on the other hand, failures or drawbacks for states in implementing an international treaty by looking at the two complementary, you know, components of technical compliance, which is the strict adherence of the implementation of international treaties, and then the effectiveness, which is the actual enforcement of the implementing laws and all the resulting legislation. Unlike the FAFT, the problem with most of the monitoring system regarding international anti-corruption treaty implementation is that they lack systematic data on effectiveness. So this is occasional, is not measured as a component, as a key component of states implementation, which is a problem, but is also, I would say, genetic to the mandate, or a genetic element of their mandates. I mean, states don't really, when they negotiated the mandates of the OECD Working Group on Bribery, of the Council of Europe Group of State Against Corruption, and, for example, of the implementation review mechanism of the United Nations Against Corruption, they expressly excluded a systematic measurement or assessment of effectiveness. And I don't really think that, based on my experience, that things are going to change, for example, next December, when the implementation review mechanism mandate for the UNCAC will be renovated. And I will tell you why. Now, what I cannot share the results of our work because it's still unpublished by UNODP, but what I can share is the methodology that we draw, and also the reference to a paper I published before actually being involved with UNODP with this project. And actually probably was that the reason they involved me, which is referred in this slides, and is published on International Journal of Constitutional Law, and is, you know, freely accessible. It's open access, so there is really no need for me to share the paper, you know, by email, because we made agreement with the International Journal of Constitutional Law that paper is along with other of that special issue are freely accessible. So most of the results I'm referring to are actually freely available in that paper, and for obvious reasons of time constraints, I cannot really expand on all the outcomes we have, but you can refer to that paper, and I would be happy also to address specific question on that. And this is the link of the paper, by the way. So now we had constraints regarding our exercise of measuring implementation through technical compliance and effectiveness. We start by focusing on a pilot of G20 countries for the simple reasons that they were more data accessible. As you might know, probably the implementation mechanism, sometimes they can't really publish the entire reports. For example, for the UNCAC, state parties agreed on publishing only the executive summary by default. And if I do not, provide consent, the whole report regarding implementation is not published, which is pretty evident if you compare the round one or cycle 1 and cycle 2 of evaluation. Cycle 1, they evaluated the chapter on criminalization of law enforcement and international cooperation, so chapter 3 and chapter 4 of UNCAC. The second cycle of evaluation for which I also contributed for the flagship publication of the UNODC, the United Nations Office on Drug and Crime. They evaluated prevention and asset recovery, and is the stark contrast between the two cycles is that there is way more full reports published in the first cycle than in the second cycle. So you have also countries that haven't, provided their consent in either cycles. Of course, there is no name and shame here. It's publicly available, but it's quite, for me at least, as an expert in this topic and on this subject, I was quite surprised that many countries, which are usually very open, also when it comes to negative or not so positive outcomes of their performance in terms of implementing international treaties. At this point in time, they decided not to provide consent to publish the full report. So the first qualification is that at the beginning, we needed to focus on a sample of G20 countries because, full data were available for that. And then we actually expanded with the use of Texas data analysis, to which I will arrive in a second, the exercise of measuring technical compliance with all anti-corruption treaties, so not only UNCAC, but also OECD Convention Against Corruption or Against Bribery of foreign public officials in international business transaction, the two convention patronized by the Council of Europe so the Civil Law and the Criminal Law Convention on Corruption, the Inter-American Convention Against Corruption, and the African Convention on Prevention and Combating Corruption. So for all, this was possible thanks to these techniques that you probably know. Otherwise, I will expand a bit on that, which is Texas data analysis. And we managed to finish well in advance compared to the deadlines we had, the assessment of all anti-corruption treaties and instruments as far as technical compliance is concerned for all countries evaluated up until 2025. And actually, in the paper that I referred to in the previous slides, you have the same results, the same methodology used for all these treaties, but data were limited to 2023 because the paper was published in 2024, but I can guarantee there were only probably 25, 30 more reports published overall. So it had the global picture hasn't changed that much. And there you can find also my independent assessment of the results. The other main qualification was that this was politically very sensitive because we were not a new treaty monitoring mechanism. The UNDP has not that mandate, and neither we aim to replace the other existing monitoring mechanism. We actually experienced some, resistance by states who questioned the role of UNDP. So what we want to have was a methodology that was objective as far as possible, because the methodology had to be based only on outcomes of existing monitoring system and avoid distortions of their assessment. And this is what we did. Actually, I use only data that were provided by the other monitoring mechanism. Of course, you can refine the evaluations, you can refine the assessment even further, but then you have to use external sources, which was not what we could do and what we wanted to do. And we wanted to be sure that the data we had were validated by countries, at least by providing their consent as far as international law was concerned, preemptively, by legitimating those monitoring mechanisms. Second, that must be comprehensive, the data set. So the methodology needed to be able to capture the main aspects of both technical compliance and effectiveness regarding as many countries as possible. And for effectiveness, this was, and this is still a problem. And provided that I have time, I will elaborate on that. Feasible, the methodology requires data that is widely available, relatively easy to collect, and that can be collected by independent entities, countries, institutions, which is also a good way to validate the data, because of course, when you collect data, you select data, you process data, you might somehow pollute the data by providing your own vision. If you use data that are public available, objectively collected by other entities which have that mandate, you avoid this problem. And again, I refer to point one, this, objectivity and feasibility go hand in hand insofar as you use data provided by the monitoring mechanism, existing monitoring mechanism. Reliable, the resulting assessment should be comparable over time and space, which is, again, something that is possible to do If you use data provided by monitoring system that have, a phase system, as also Jennifer referred to her in her presentation, for example, Canada now is in phase 4 of the OECD evaluation process, and which started in the early 2000s, and can update, which means that that assessment process can update its own results and evaluations by looking at the innovations and also maybe new problems which a certain legal system, domestic legal system, might present over time. Interpretable, the assessment based on the methodology should be easy to relate to its underlying components, which is something that, again, might be problematic when you use sophisticated Texas data analysis or automated process, which are not readable or easily interpretable for example, for a normal legal expert which doesn't work with IT process. I myself had to use a small team of IT expert to enlarge my idea to the methodology, and then global methodology should be able to grow over time as more countries and year are added to the data. So that was our objective, and that was what we tried to do. Again, as I said, we use a standard, I would say, because that was, it's not standard because you don't really have other international criminal law initiatives which are measured in terms of both technical compliance and effectiveness. You have only technical compliance except for the FAFT. And again, the FFT to me is unique. And, the fact that I can at a certain point, by moving to phase 4, or the cycle 4 of the evaluation, they move to a new methodology by inserting goals of effectiveness, for me was very much motivated by the fact that money laundering was associated with, financing of terrorism, and financing of terrorism, draws or, is a kind of, I would say, collector of consents by states. It's not, it's no coincidence for me that, the FTT has, always been backed up, for example, by the US, no matter which kind of administration or president was in time. This is very different for corruption. So for corruption, you don't have, unfortunately, that kind of, of support, of multilateral support. And as I said, in fact, you don't have, effectiveness measured by monitoring system on systematic and, comprehensive basis. And for technical compliance, the innovation we introduced was, we have data from 4/5 monitoring system, international monitoring system, which measures implementation of 5, actually 6, because Council of Europe has 2 international anti-corruption treaties, plus also many soft law initiatives or instruments, because the OECD and the Council of Europe, they monitoring system, they monitor also the implementation or the adoption of their recommendations, which is not something that other treaties. 3 minutes, please. So as I said, I cannot then go on everything, but just to provide you with the effectiveness, I won't go to the with the technical compliance. Why did we use Texas data analysis? Because that way we could fundamentally process data, for all treaties and for all countries. So just to provide you with an example, now is stuck. Here you read the advantage and the problems of measuring implementation of anti-corruption treaties in terms of technical compliance using Texas data analysis. But here you have kind of sample of results. For example, this is we created a database by using Texas data. Texas data fundamentally use algorithms to identify cluster of text which is not processed by human intelligence, and then you have to validate and to double check it with your own work. But it allows you to fundamentally to process way more data, is referred to in a previous slides than this, than a team of lawyers or could do in not in the same amount of time, but maybe even 3 times as much. And here you have the number of successes, and and then you have the same for or drawbacks or challenges, as the implementation review mechanism called them, because they cannot really call them, failures. And you see fundamentally percentage of successes. And then if you look at the paper I published, which is hyperlinked here, you have also the link there, the entire data set, which means that you have the kind and explicit reference to the problems and the achievements which were found through this system by using Texas data analysis. And for example, you have many problems regarding prevention, many problems regarding protection of whistleblowers, which is horizontal. I mean, it's whistleblowers and preventions are really, something that were kind of, assessed as still lacking in many countries. You have a lot of problems regarding collection of data by public enforcement, by administration. So I really, I was confident when I saw Jennifer's presentations, because her outcomes or her assessment are pretty much extendable to most of the countries here. I don't really want to spend much time because, again, time is a factor. I understand. What I wanted to show you is that the further step we did, and this is with this I will finish, and I will just spend 2 words on effectiveness, was try to reduce to this data set. And that was the political sensitive issue in a sort of measurement, either to synthetic indicators such as fully implemented, partially implemented, not implemented, or largely compliance, or not compliant at all, or then translated to this synthetic element in numbers. We could do that, and we did it. The problem was that was perceived by state as a sort of ranking of and that was something that they really didn't want. Our actually aim was to provide them with more readable and easier to use data set that kind of huge reports to to drive their own reforms, so also to ask for targeted technical assistance by international organization. I think we did it. That was kind of really appreciated by most countries, but with some countries seeing themselves as assessed as like a low rank or a low number, low synthetic indicator was a problem. To me, it was surprising because, as you see in the slides, OECD Working Group on Bribery and the Council of Europe Group of State Against Corruption, they use the exact same words. They have that mandate. They could do that. What we did was only to expand and to refine this assessment and this sort of assessment to the larger number of states, which is assessed under UNCAC. OECD, you have 46 states, maybe even less. You have less states for the Council of Europe Group of State Against Corruption. In UNCAC, you have 191 states. And, again, we did that. You find also the same exercise in my paper, but I think that with the UNDP, we arrive at at a further level of sophistication, because also we introduce a system of ponder, and you have examples in the next slides here. I mean, it's just the slides. I think the slides will be published with my presentation, and we will be happy to respond. But in these slides, you have also example. This is anonymized. The ponders I use in these slides are kind of figure out. So this is not a real country, to be clear. It's not going to be creating any problem, but the system is very simple once you have processed the data. I'm sorry, I realized that I took more time than what was required, but I will be happy to respond to any question or to expand on my presentation in the next few minutes. Thank you.
Thank you so much, Leonardo. I don't see any questions in the Q&A, but I'm wondering, do any of the speakers want to ask a question of Leonardo before he leaves us? I think it would be great if we could share the slides.
No, I mean, you can of course share the slides. I will send you
Okay.
the slides, and you can share also the paper. So I would be also happy to. You can also share my contact. So if any people who kind of attended this call and this presentation and then had time to look at the slides want to reach me out, I would be happy to respond.
That's wonderful. Thank you so much, Leonardo, and have a good evening. I know it's very late and it's
Thank
been
you.
a long, hard day for you. Thank you so much.
Thank you. Bye-bye. Thank you.
Bye-bye. Our next speaker then is Martin Kenney, And Martin will be speaking, he's going to be telling us all about his legal practice, which sounds absolutely fascinating, about asset recovery in response to serious fraud and grand acts of corruption, public wrongs, private responses, private actions, civil lawsuits to recover stolen public assets, and the need for public-private partnerships in global asset recovery in response to these grand acts of public corruption. He'll also talk a little bit about the UNCITRAL Working Group on Insolvency. So, Martin, over to you.
Thank you very much. I don't have a PowerPoint presentation. I'm just going to speak orally and extemporaneously with a small note. I'm a fellow Canadian. I'm speaking to you from the island of Tortola in the British Virgin Islands, which is a group of 60 islands and cays, beautiful part of the world, with 2,000 catamarans, the largest private charter fleet in the world of catamarans. And we have also 375,000 active business companies formed under our BVI Business Companies Act, holding what we estimate might be $1.5 trillion of value around the world, principally in other places, of course, not here. However, our commercial court has jurisdiction over all of these companies. And so when they get into difficulties or are up to no good in terms of the people standing behind them involved in fraud or corruption, then we can race off to our high court in our commercial division and get various forms of relief in favor of victims. So I have, as a lawyer I've been a lawyer 42 years now, and last 35 years I've been in New York and in London and Dublin, and last 20 years here in the BVI doing one thing and one thing only, and that is acting for victims of global economic crime, serious fraud, grand public corruption. So the spectrum of clients of our practice are both on the private sector side, the full spectrum of clients, including sometimes I'm working right now on a new crypto investment fraud where €1 billion have gone missing through 2 BVI companies. And we act for 44 Australian victims of fraud and discovered 150,000 other victims in this €1 billion scheme. Sometimes we act for corporations, like Nissan Motor Company. I've got the brief to act as the Worldwide Asset Recovery Council against former chairman and CEO Carlos Ghosn, who fled Japan 5 years ago in a music box to avoid criminal justice in Japan for Lebanon, where there is no extradition treaty anywhere. However, we frozen his super yacht and have found assets in a number of other jurisdictions that we're dealing with, and had a trial here in our commercial court dealing with fraud. And Justice Gerhard Wohlbank concluded that he is responsible for a fraud on Nissan to the tune of $32 million taken from the CEO Discretionary Business Development Fund. We act for sovereign nations, a West African state in their anti-corruption unit. We are advising the Republic of South Africa in issues arising from the Zondo Commission report, where Chief Justice Zondo, after 4 years of work and $65 million of spend on his commission's inquiry, concluded, having examined with silks in the room, cross-examining witnesses, and seeing thousands and thousands of documents, that $52 billion of value was stolen from state-owned enterprises from South Africa through the instrument of state capture of the SOEs by a number of individuals, including the famous Gupta brothers, who fled South Africa for Dubai, beat extradition on technical grounds, and now are in other locations. So that's sort of a broad picture of our practice. But I want to cover 4 points quickly, a whistle-stop tour. One, what is asset recovery? The fundamentals. Well, there are 2 parents to asset recovery. One is public and one is private. Before 2000, none of us working in this field knew what to call it. We didn't know to call it asset recovery. There were no conferences, there were no university degrees, there was no real advanced learning in the field. It was created really by two things happening in parallel, separate. One, certain public sector instruments, the big one, first one being UNCAC, the United Nations Convention Against Corruption of 2003. And for the first time in an international convention, the words asset recovery can be found in that convention and a whole part of it, where ostensibly the signatory states, of which there are many, obligated themselves to cooperate in asset recovery. And if you were to look in Wikipedia for the definition of international asset recovery, is defined as any effort by governments to repatriate the proceeds of corruption hidden in foreign jurisdictions. I dare say, being on the private sector side, that's half the story. We on the private side have there many serious professionals at the bar in many countries, and insolvency practitioners, forensic accountants, former police officers or detectives, who all work together in a suite of disciplines. That's the other unique part about asset recovery. When you're a practitioner as a lawyer, you learn very quickly that there are limitations in what young lawyers or older lawyers can do. We can put briefs together, we can do arguments, we can develop facts, but without these other disciplines, we're lost. We need to have access to a whole suite of human disciplines to be able to put on a case and to trace value around the globe, locate it, define its holding, obtain attribution evidence to wrongdoers and wrongdoing, and to suddenly, preemptively freeze it with the assistance of many judges in many countries. So in terms of the fundamentals, we do dual directional tracing following the fructus sceleris, the fruits of fraud, from the point of the scene of the crime or the apparent fraud forward, following the money in a traditional sense. Also, concurrently with that activity of forward tracing, we do reverse tracing from the point of the scene of consumption or the expression of dominion or control over something of value. For instance, we always ask ourselves, well, there's the subject, he's in a super yacht. Somehow he's got a crew of 35 people with a big payroll. Who's paying the crew? How are they being paid? How are they paying for the fuel on the yacht, which could be a massive bill every month? Let's sort that out. And then we always ask, which law firm or accounting practice designed the system for money laundering in this case? Because typically, if we can figure out who the model builder was, or the designer of the instrumentation with layers of companies and bank accounts moving value anonymously around the world, we can very rapidly solve a case if we can get an Anton Pillar order, a search order, or mini Anton Pillar order, a scan and deliver order at the doorstep of a Cayman Islands law firm. For instance, I've been to many times, one in particular, serving such orders and trying to solve these cases. So we do this dual directional tracing. The other thing is we have a need for utmost secrecy. We are the tortoise. We are tracing and following the hares. They move much more quickly than we can. We are slow, we are lumbering, we are deliberate, but we need secrecy. With secrecy, meaning we invite judges in disclosure orders to seal the record, anonymize the names of the parties in the court public list, gag banks, law firms, accounting practices with gagging injunctions not to tip off the underlying subjects. And we ask for all these ancillary orders to wrap them around a disclosure order so that we can, over time, maybe in some cases over 2 or 3 years, with perhaps more than 20 of these orders around the globe, assemble a record of objective evidence of attribution, of value to wrongdoers and wrongdoing. If there's one thing I would like to leave you with, that is what we do. If we get attribution evidence linking value to wrongdoers or wrongdoing, we will find value and we will preserve it and we will likely recover it. Now, the other thing I will mention is that this is really about value recovery. Asset recovery is too limited. As I said, this Wikipedia, unfortunately narrow definition of what asset recovery might be concentrates on the recovery of bank account value, real estate, vehicles, artwork, artifacts, precious metals, and now dare say cryptocurrency, blockchain value. That's one kettle of fish. The other, actually in many cases, the bigger target are banks, law firms, accounting practices, trust officers, and their companies. These persons are involved either in the primary wrongdoing or usually the secondary ancillary sequelae, the hiding, the concealment of the proceeds of corruption and fraud. If any of those persons, and when we're doing the first activity of dual directional tracing, we identify all these enablers and we rank them on a scale of 1 to 10 of responsibility or accountability. Have they committed negligence? Do they owe a duty of care to the client? Have they participated knowingly in a fraud to give, let's say, dishonest or knowing assistance in the breach of a fiduciary duty? Have they been recklessly indifferent to all manner of risks by, one English High Court judge said, indulging in willful blind eye knowledge of the obvious risks? When they do those things, we can establish liability civilly and potentially recover hundreds of millions of dollars of value or billions of dollars of value against a bank that's done bad things. So it's not just about tracing traditional assets, it's also about building large value facilitation liability suits against enablers of corruption and fraud. That's enough to be said about the fundamentals. Quickly, we need to advocate the need for public-private partnerships in global asset recovery in response to grand acts of public corruption, because both the public and the private sectors have strengths and weaknesses. Public sector recovery models usually are surround cross-border cooperation under mutual legal assistance treaties, MLAT requests, or the Egmont Group, which is a group of financial intelligence units sharing intelligence about assets and the financial affairs of perpetrators of corruption. That's all fine and dandy, but I can tell you, I can assure you that that model, you talk about slow and lumbering. One case, there was a judge in Brazil who took a $5 million bribe from a senator who wanted a contract to build the labor court and administration facility in Sao Paulo about 35 years ago. The $5 million ended up in a bank account in Switzerland. The bribe money did. In another bank down the street were $200 million of monies stolen from the people of Sao Paulo through the construction of this facility by the senator, who obtained the contract to build the facility through bribing the judge who had the authority to hand out the contract. That $5 million was frozen in about 1999 under an MLAT request from Brazil to Switzerland, and was still kicking around there, frozen until 2023, when one of my colleagues in Switzerland in the private sector side had finally been instructed to sort this out, and he did within the course of 6 months. So we in the private sector side, we can go to court and get orders more quickly to support the G2G government slow and lumbering MLAT mutual assistance request model. We can also provide technical assistance to public sector partners. I was just in South Africa 10 days ago, and after going 4 times in doing conferences and educational events there, we now have people like the Director of Public Prosecutions, the head of the National Prosecution Authority, a senior member of the central bank of the country, all speaking the language of public-private partnerships. That's the way to go in asset recovery today. And if you're not doing that and supporting that, then you've lost the plot, because it's not going to happen in an efficient and worthwhile way. We also deal with litigation funding sometimes. Funding is a big problem in our space because it's of the speculative nature of asset recovery. We have to raise capital. Sometimes public sector, in South Africa, they have a fund. They've set aside $70 million in something called CARA, the Criminal Asset Recovery Account. So a portion of the proceeds of recovery domestically from the huge Zondo Commission findings have gone into this account. There's $70 million sitting in it, available ostensibly to help fund forward risks dealing with international asset recovery for the people of South Africa. So if you're on the public sector side, it's good not to put all the money that you recover in these cases into the Treasury. It's good to seed capital fund forward other risks. I refer to our cases as risks because that is what they are. The last thing I'll say, with my limited time, is UNCITRAL's Working Group 5. It's a little-known working group of UNCITRAL, the United Nations Center for International Trade Law. In 1997, they developed their model law and cross-border insolvency cooperation. More recently, they've issued a toolkit and background notes on asset tracing and recovery in cross-border insolvency proceedings. It's interesting. It's another example of private and public sector instruments and ingenuity. Insolvency and bankruptcy sort of lies in the middle. Some in old times we would call bankruptcy a quasi-criminal affair. The World Bank has a technical body called STAR, Stolen Asset Recovery Initiative. STAR wrote Going for Broke in 2019. I helped to edit that work. And they had an excellent piece, which I commend to everyone who's interested in this area, that was published in 2015 online, called Public Wrongs, Private Actions, Civil Lawsuits to Recover Stolen Public Assets. So the last thing I'll leave you with is imagine a world where we recognize that when a state is a victim of grand corruption, it has civil rights. It can bring civil lawsuits in most of the world's rule of law based jurisdictions, or all of them. It can bring a private, not private prosecution, but a criminal complaint in Switzerland. In most of our cases, when money goes to Switzerland, we file a criminal complaint, and the victim is a partie civile in the criminal proceedings, has access to the Swiss bank account records, has access to restitution, has access to appeal rights if they disagree with the prosecutor's decisions. Whether you're a public sector victim or a private sector one, you can use local criminal or civil or insolvency proceedings to get at the value, freeze it, and recover it. With that, I think my time is up. Thank you very much.
Thank you, Martin, for that extraordinarily interesting description of your day-to-day work. It sounds wonderful. Now we're going to turn to Juanita, Olaya Garcia, and she's going to speak from the perspective of advisory work as a consultant on governance issues, how to foster integrity, challenges and innovation in international law. She's also going to talk about the paradoxes of international law and innovation. Over to you, Juanita. Thank you.
Yeah. Thank you, Oonagh. I hope people are seeing the presentation.
We see it now.
Thank you so much. I would have a couple of questions for Martin, but let's see for the Q&A section because there have been very interesting presentations. As you mentioned, Oonagh, and thank you for the invitation to share here a few ideas that belong to a greater part of work I'm doing right now on international law and innovation. I work in the field as well as Martin, but in another moment in time, perhaps. I help organizations, public and private, who want to improve their integrity systems, their anti-corruption systems, who are experiencing corruption and who want to make it stop, to help them stop through organizational changes. This is a part of the work that I like the most. I also like to teach and write a lot. So there's also a lot of reflection process in the work I do. So what you will hear today and what I bring today for you briefly is a bit of both, and is a reflection a bit more from the forest, let's put it that way, where you could even take from the presentations from Jennifer, Martin, and Leonardo a bit of examples of trees of that forest, because it connects very well with what I'll mention here. When you talk about innovation in international law, it's a bit of an oxymoron. We think of international law as something very static to a certain degree, despite customary law. I want to argue and I want to show that the space of innovation and the space that innovation has within international law is actually built in the space that some paradoxes that we see happening in international law bring about. What are those paradoxes? One could argue within the system that exists, and if you remember what have Martin, Leonardo, even Jennifer mentioned, you could say both that international law is both necessary and useful, or irrelevant and useless. And both statements could be completely true. Now, brought to the area of corruption, you could ask, well, is international law actually the right means to tackle corruption? And you could definitely say yes, or you could say no, with the same strength. You could say yes, because as you see, corruption is a transnational issue. The architecture that has been built with different types of treaties, of agreements, etc., have been necessary. They have been brought about also a number of significant change to the world. But also you could say, no, it's not relevant. No, because international law is not meant to change human behavior. Just as you wouldn't use international law to change alcoholism or to treat alcoholism, for example. And you could say also no, because of the things you hear. Most of it stays on paper. It's difficult to implement. You even hear Leonardo struggles to explain or to share the results on his paper. And I had to, not to laugh, but to smile internally, because, all those problems about anonymizing countries, the difficulty of putting together reviews of similar topics, even within similar topics. So you could say, well, no, the international realm and international law is definitely a cumbersome, a very slow, as Martin also mentions, aspect to, or tool to tackle corruption. I see also that in the current circumstances on the world, and this is where I want to deepen a little bit my presentation on, this gap, this paradox between is totally necessary or is totally unnecessary gets even wider. And I want to explain which of those, what I mean by the current circumstances. Very briefly, and I have shared some links also on the chat, because you will see what I'm explaining here in a bit more elaborated form, in the form of an essay in my Substack in the next few weeks. So when you want more details, which we won't have in this time, you will be able to have them there. What do I mean by our current situation? Just 4 critical points of our current situation that makes me believe this gap, these paradoxes between yes and no, useful, not useful, make this paradox even bigger. First, we have lost consensus, or it's broken, on what really public interest means, locally, regionally, nationally, internationally. And what is the public interest to defend? Partly because we have been focusing on modes of corruption. As you see, what are we talking about? Is it state capture? Is it not state capture? What do we mean by one? What do we mean by the other? We have lost consensus on some basic values, internationally, regionally, nationally, on values like freedom or respect of life. And this is important because corruption should not be confused with the offenses of corruption. Corruption is a phenomena that is about prioritizing the public interest, the private interest over public interests. But if we don't have clear what that public interest is, how are we going to prioritize what over what? And this creates a domino effect, because we have forgotten that this consensus is the basis of rule of law and is the basis of institutions. So when we talk about things don't get enforced, things get enforced late, things are being delayed, what are we talking about? Are we not implementing them because we don't want them, for example? Second point, some old views that would have been valid in 2003, in 1980, 1970, 1952 perhaps, are not valid today or have lost sense. For example, the extreme focus of international law on nation states as the only actors. I think Martin hints a little bit on that, on the difficulties facing asset recovery, for example. But also on seeing the states as monoliths. We keep seeing states as monoliths, and we are actually contradicting, for example, the plea we have for independent justices. Why? At the international level? Because international diplomacy goes through the executive anyway, for example. But we keep seeing states as monoliths. Second point there, which I find very important, and in a way, we all until now have talked a little bit about it, which is the world is terribly fragmented. By this, I don't mean only the polarization we're experiencing in different countries between left and right, up and down, but about the fragmentation of the issues and particularly the collective problems we're dealing with. So we talk about corruption, and it's totally separated from human rights, from climate change, from environmental damage, from organized crime. And you see even the previous presenters think there are necessary and feasible connection with other topics, inclusive, financial issues, etc. But we have fragmented the world, and it was necessary at some point, this fragmentation, because we were starting to deal with these issues. So we needed to develop a specialized knowledge, structures, policies, plans to deal with this. But now we have such fragmented world in terms of the topics, and we're giving room to a lot of contradiction, duplication, inefficiency. See only what Leonardo presented only within the realm of corruption is practically impossible. I mean, there's no interest in assessing effectiveness, which is already interesting enough, but it's very difficult also to make sense of the review mechanisms of, even within the realm of corruption, of those review mechanisms altogether. And we're splitting hairs, quite frankly, on issues that are not separated. They are inherently connected in the complexity of our human experience. Third point, there is a tendency of the world towards autocratization. Democracies are getting weaker. And I have the data here, but for the sake of time, I'm not going to dwell too much into this. But basically, more than half of the world is living now under autocracies or weakened democracies. So what this means is the gap between governments and citizens is getting wider and wider and wider. And this may not be very clear for Canadians. You are privileged in many ways. But it is very clear for many parts of the world, including your neighbors in the US, who are suffering from this quite acutely. So this divide between, if we are living in a world where there is a big divide between governments and citizens, we cannot continue in an international legal system that is focused on nation states, because we're only reinforcing that dynamic. We're keeping out a great number of population of the world that is actually being oppressed by the very same governments we're negotiating with. So that is a huge problem. And again, what is happening is that at the end, international law is not working for the citizens, and it should be working for the citizens. Ultimately, international law and international governance order is supposed to be made to, I think at least, save our species. If not, what for? To put us limits, to make us be able to coexist. But if the gap between citizens and governments is getting wider, we have a real mismatch. And finally, fourth point of what the current reality is and why I think this paradox gets even more extreme is the problem of what I call the problem of spaces. Governments are really not equipped to deal with the spaces. Which spaces? The cyberspace, including artificial intelligence, including the gaming world, including internet, you mentioned it, whatever inhabits that cyberspace. The outer space and the civic space. And not only is our governments not equipped to deal with it, but there are also spaces that are currently being handled, managed, created, and dominated by millionaires or trillionaires or super millionaires, however you call it. Millionaire sounds already too restricted to be true. So in this world, what role does international law have, and what role does it have vis-a-vis corruption? Are we still thinking about, 20, 30 years ago, where we had a totally different world? We have to think about the world we have today and its challenges. And as I mentioned, I think it is in this gap, in this paradox of two totally true statements, international law works fully or international law doesn't work fully, that we have an innovation space. And let me just, for the sake of clarity, when I say innovation, I mean really paradigmatic changes in that realm. So I'm not going to refer to this. My colleagues, Allan and Robert, are going to talk about the International Anti-Corruption Court. Just to be clear, when I say innovation, I don't mean an International Anti-Corruption Court. A new institution is not an innovation. That's a new institution that's built within the paradigms of what we have. I think that what we need is a paradigm change in many subjects. When you talk about a paradigm change within international law, you could say, well, let's do a complete revamping or a revolution. That's not what I'm saying. Or we could go, which is for proposals, which is interesting, and I invite you to read the China's Global Governance Initiative, for example. That are, to my surprise, quite conservative in their proposals, is much more about sticking to what we have right now, but making it work. It's not very clear and not very detailed on how do they want to make it work. But what I want to propose today, and a few ideas, are perhaps somewhere in the middle and are more based or oriented on towards how to make international law be made more useful. And be mindful that I'm talking about not just for corruption, because I am assuming really we do need to integrate the issues. And that's my first point. How can international law be made more useful? Integrating issues. We have a very fragmented world, and we cannot have companies evading taxes in one corner and having sustainability obligations in another and think that that is consistent. We need to make relevant connections among issues to reflect, I have a grammar mistake there, to reflect the complexity of our collective problems accurately. What do I mean by relevant connections? We can discuss if there's time for that. Integrating issues also means putting people at the center. And what do I mean by this? Let me give you a few examples we've related to the presentations before. Putting people at the center means including the effectiveness is the goal of those review mechanisms that you see Leonardo is annotating as missing. Putting people at the center means that Martin's presentation will not only be about getting redress for individual victims, but getting redress for collective victims of corruption who are there. Those not having hospitals, not having health attention, not receiving education, not receiving the funds they were supposed to get through their public goods. That's what, for me, means putting people at the center, which is, by the way, also an element in the Chinese proposal. Interesting enough, without details. Second point, recognizing rights and liabilities of both individuals and companies. We cannot live in a world where individuals and companies are not subjects of international law equally and with the same powers and levels as nation states. Because we are in the world this world needs to reflect the international governance system needs to reflect the reality of what's happening on the ground. And I am convinced that citizens, as complex as it is to bring citizens to the table, should have voice in all fora, which they are not having. And I mean citizens, I don't mean NGOs. We could also discuss about what the mechanisms can be, how complex that can be. But I think it's time that we stop being so less courageous with complexity than we are being. We also need to introduce agility to international governments, make it a bit faster, react a bit quicker. And this, of course, is a domino effect. Public institutions are not particularly fast. Martin mentioned this very explicitly with his own example. But we need to speed up intervention, international intervention in certain issues. And this may need or require that we reduce subsidiarity and complementarity in sensitive situations. Let me give you an example from this week. In situations where corruption is aiding genocide or vice versa. Why did it take 2 years, which, by the way, the Gaza Strike case is a case of corruption in human rights. Again, it's integrated. 2 years to stop a genocide is not... Yeah, 1 minute, I'll be with. We need more realistic decision-making processes involving the right stakeholders, changing the processes we have now for majorities and veto powers, less monolithic type of relations, and monitoring and review mechanisms of the different topics need to be more integrated. And finally, if I say consensus is broken, well, of course, I think we need to build a renewed agreement and a new commitment on what matters to us as a humankind, because it's not clear anymore. It's definitely not clear anymore. And I leave also a question which has a lot of assumptions, just for us to discuss, or maybe continue the discussion at some other point. Why should or can international law reward integrity in the world beyond the Nobel Prizes? And should it? Our focus tend to be too much on the criminal law approaches, perhaps even the civil law approaches. But maybe international law could be also a space where we really reward and model the type of integrity we want to see all across. Thank you very much.
Thank you very much, Juanita. Our next speaker is Allan Rock, and Allan will introduce the proposal for an international anti-corruption court, the problem to be addressed, why the IACC is a solid and elegant solution, and an overview of its basic pillars. So with that, I turn it over to you, Allan. Thank you.
Thank you very much, Oonagh. And what a privilege to be part of a panel with such knowledgeable people. And I put all my colleagues on notice that I shall be in touch with you in the days ahead to pursue some of the thoughts you've expressed, to learn more from you. It's been wonderful to sit here and listen to people with such deep knowledge of these issues. Thank you so much for work and for being part of the panel. I guess my threshold question is, I'm here to propose or to support the proposal for a new international institution. And the question becomes, given what's involved in creating such an entity, is it worth it? Is it worth the candle? I mean, we live in a world that's topsy-turvy, where the rule of law and traditional legal principles are very much in issue. And at this vexed time, is there a case for creating this new international institution? And in responding to that question, I guess I first start by referring to the scale of the problem of grand corruption. It's very difficult to get one's hands on precise numbers when it comes to estimating the cost of grand corruption, but the best I've been able to do is to go to reliable places like the Global Financial Integrity Center, which through research tries to measure the costs of corruption. And they say that developing countries lose to corruption every year an amount 10 times greater than the amount they receive in development assistance. And that loss has consequences. There are very significant results, including some life and death consequences. Transparency International estimates that corruption in the health sector globally results in the preventable death every year of 140,000 children. Now, grand corruption impedes the achievement of some of our most important objectives. Look at global warming and climate change, for example. At the COP29 conference in Azerbaijan 18 months ago, it was agreed that commencing in 2035, developing countries will receive $350 billion a year to assist them dealing with the consequences of global warming. To what extent can we be confident that that massive amount of money is going to be used for that purpose? Surely we have to do something beyond what we're doing at present to try to increase our confidence in that regard. Grand corruption does not exist because of a lack of laws. Look at what we've heard over the last hour, these knowledgeable people talking about the extensive and complex, sophisticated laws, certainly in Western and Northern countries, to deal with the issue. And in fact, there are 186 states parties to the UN Convention Against Corruption, and that convention obligates every one of those states to enact domestic legislation creating as criminal offenses some of the classic corrupt practices, including bribery and so on. So the challenge is not creating new laws. We have lots of laws. The challenge is in the enforcement of those laws. And the worst offenders when it comes to grand corruption are often in control of the police, the investigators, and the courts. So they've sealed off within their own jurisdiction any avenue for accountability for their own wrongdoing. And indeed, our neighbor to the south, the United States, has declared that it's not enforcing the Foreign Corrupt Practices Act. It remains on the books, but it's not going to be enforced. So we have laws. The question is enforcement. And yet there's no international institution that's able to hold these kleptocrats to account. As we approach the task, the daunting task of creating this new international institution, we should bear in mind that we're not starting from scratch. There are already significant elements in place, a very high degree of collaboration and international cooperation on anti-corruption. One thinks of the International Anti-Corruption Coordination Center, in which 8 major economies are participating. One thinks of the post-9/11 anti-terrorism and anti-money laundering provisions that Jennifer referred to. And one thinks of the Financial Action Task Force, which is there to ensure that those provisions are effective. But the enforcement gap remains. So what do we propose? Well, Juanita, we propose an innovation. We propose a new institution, first of all, that would operate on the principle of complementarity, much like the International Criminal Court does. In other words, we don't touch upon or interfere with the sovereign right of each member state of the United Nations to investigate and prosecute corruption, but the International Anti-Corruption Court will be available should states be unable or unwilling to do so. Second, the IACC would provide a politically neutral forum to investigate and prosecute fairly and effectively kleptocrats and their enablers, the lawyers, the accountants, the business advisors who facilitate the commission of these offenses. In addition, the International Anti-Corruption Court, in my respectful view, would act as a deterrence, deterring because it represents a credible risk of prosecution and consequences, one that apparently does not exist at the moment. The International Anti-Corruption Court would ensure also that there was a forum in which victim states could pursue the recovery of looted funds, and Rob Currie will be dealing with this in more detail. And finally, the International Anti-Corruption Court can make its specialized expertise available to states that are seeking to strengthen their own capacity to investigate or prosecute. So what crimes would this court prosecute? Well, it's very straightforward. They would prosecute the crimes provided for in the United Nations Convention Against Corruption. These are not new. They're known to 186 countries who are obligated to enact domestic legislation recognizing these crimes. So the court would be there to fulfill the promise of the UN Convention Against Corruption for states that are unable to do it for themselves. Now, there are questions that typically arise. I'll touch upon them briefly. What if kleptocrats don't join the court? A crooked leader of a country won't be attracted to joining the International Anti-Corruption Court. Well, to that I say they may not, but they need not, because the court will have jurisdiction to deal with acts, not only of the nationals of states' parties, but also would have jurisdiction over acts committed in the territory of states' parties. So kleptocrats who take the money from country A and put it on deposit in country B, if country B is a state party to the International Anti-Corruption Court Treaty, the court will have jurisdiction. What about the expense? There's a lot of complaint about international justice at the ICC being expensive and lacking in productivity. Well, just to put that in context, it costs roughly $300 million a year Canadian to operate the International Criminal Court at the moment. That's the cost of about 4 F-35 fighter jets. So I think it's important to keep these numbers in context. But even there, one of the prime movers in the effort to create the International Anti-Corruption Court is Justice Richard Goldstone from South Africa. And he was asked some years ago to do a 20-year review of the International Criminal Court. He produced a report identifying ways in which its practices and procedures can be simplified and strengthened to reduce cost and make it more productive. And Richard Goldstone is bringing that experience and those insights to the design of the Anti-Corruption Court. For example, no marble palaces in The Hague, no standing complement of judges waiting for cases to come in. The judges will be available when the cases are before the court and not otherwise. And investigations will be conducted in partnership with states' parties. So we use the facilities and the resources of states' parties to pursue investigation. What about the difficulty of proof? Well, that concern is becoming less and less significant as time goes by. The registries of beneficial ownership are becoming more common. Unexplained wealth orders are becoming more common. The tracking and tracing by states around the world is becoming more sophisticated. And indeed, there are journalists, such as in the Panama Papers, who are documenting a lot of what has to be proven in allegations of this kind. Public-private partnerships, as Martin referred to, can also assist. Let me close by touching upon just two things. Where do we stand with drafting the treaty? Justice Goldstone presided over a committee of 15 international experts who've been drafting the treaty for the last 3 years. And they, in turn, have had access to an advisory panel of some 20 experts in international law who've provided answers to questions that have arisen in the course of the drafting. The draft is complete. We've shared it with 32 governments around the world, as well as some civil society organizations for their comment and reaction. We're going to harvest their comments and suggestions. And in early 2026, we hope to produce the next iteration of the treaty, make it public, and bring the entire world into this conversation. Who supports this proposal? Well, I'm proud to say that Canada does. Both major parties in our country have written it into their electoral platform that they support the creation of the court. The UK Secretary of Foreign Affairs has expressed support for the proposal. The European Parliament adopted a resolution in support of creating the court. Latin American countries, Colombia, Ecuador, African states, DRC and Nigeria, in Europe, Moldova, the Netherlands. And let me just close by saying that there's another source of support for an international anti-corruption effort, and particularly a court. Over the last 2 years, we've seen the most remarkable demonstration of discontent on behalf of young people who have gone into the streets and literally overthrown their governments because they're fed up with corruption. They themselves have been asked to live with less. Many of them can't find a job. Their economies are stagnant. The investment in social and public services are down. And meanwhile, corrupt governments are creaming money off the top. I can refer to Moldova, to Serbia, to Bangladesh. I can refer to Nepal, Morocco, Kenya, Uganda. In every one of those countries, young people are in the streets and often overturning their governments, demanding an end to corruption. The tide is turning. Yes, this is complicated stuff. Yes, it's difficult to create a new international institution. And there are challenging issues of law that must be confronted. But the time has come for change. The numbers I referred to at the beginning, those massive amounts that are stolen every year, that can't go on. The global public won't tolerate it. And I'm here to suggest that there is growing support in every quarter of this globe for an initiative such as the one I've described. I'll leave it there and turn it back to you. Thanks, Oonagh.
Thank you very much for that, Allan. Very persuasive argument you're making, and I look forward to seeing that draft. Our last speaker, very patiently waiting, is Robert Currie, and he's going to explain the proposal for the assets division, which is a new innovative part of the proposal for the International Anti-Corruption Court. So I'll leave it over to you, Robert. Thank you.
Great. Thanks very much, Oonagh. Let me echo what Allan said. I'm delighted to be in the company of a really distinguished and interesting bunch of experts, and happy to offer a few remarks on this particular part of the IAC proposal that Allan has so ably introduced. And I threw a link to a very, very recent article updating on developments in the drafting of the statute, which, as Allan said, we'll see next year. But that's there for your pleasure. So, in our view, there's a lot to be excited about with the IACC, and maybe worth mentioning. Allan and I were in on the party of drafters and consultants who were involved in putting the project together. One of my roles was to be co-chair of a subcommittee that drafted this part of the proposed statute that I'm going to be talking about. I do need to give credit to my co-chair, Jeff Simser, who a globally prominent money laundering expert who had the expertise and the vision to help generate this. So the idea, the innovative idea is this: the IACC will be a criminal court, but it will be more. Because putting the perpetrators in jail is important, but so is finding the money that they have stolen and putting it back into the hands of the people from whom it was stolen. And since we're talking about grand corruption, that means money that was taken out of the national tax base of a country and should be going to fund social services and healthcare, build roads and infrastructure and so on. So the proposal is to have two divisions of the court. There will be a criminal division and an assets division. Now, the function of the criminal division is pretty obvious. It's where the criminal trials will happen. But the assets division will have jurisdiction over everything to do with assets that are tainted in some way by corruption crimes within the jurisdiction of the court. So I'm going to break this down into four basic functions. First, if a person is convicted of a corruption crime, then anything to do with assets derived from that crime will be handed over to the assets division. It'll be a separate proceeding from the criminal proceeding. The prosecutor will be able to make an application for forfeiture of those assets before the assets division, a separate chamber of the court, if you will. In the statute, forfeiture is referred to as recovery, but it's the same concept that we're talking about. And the fact that assets have been identified as resulting from or being attached to a criminal conviction means that the court will presume that they are indeed the proceeds or instrumentalities of crime, which is very helpful from a proof and evidence point of view. The court will then have the ability to either order the assets returned to those from whom they were stolen, or to order something else done with them. And this option of an alternative to simply returning the assets is an important one, because it deals with problems that are well known in the anti-corruption world, and indeed that have come up here today. With the proceeds of corruption, especially grand corruption, there's always a chance that the assets will be re-corrupted if they're just returned to the government of the state from which they came, if they're handed back to the kleptocrats who stole them or allied parties. So the court can take this into account and come up with better and more accountable ways to repurpose the assets. This will not be an entirely discretionary decision, but one that's based on criteria that are enumerated in the statute. So that's the first function. Second, even if there is no criminal conviction, the prosecutor will be able to make a freestanding application for what in this world we would appreciate to be non-conviction-based forfeiture. Now, in some cases, this will be preceded by an application for an unexplained wealth order, which is an increasingly popular tool in the anti-corruption and anti-money laundering space. I dare say Martin runs into this in his practice. The prosecutor in this kind of a situation will lead evidence on the application to establish that the individual's personal income and assets are inconsistent with their known income and resources. So your paradigmatic person is the high-ranking government official who makes $100,000 a year, but owns 2 yachts and 3 houses and vacations in West Palm Beach. So when that is established, the onus shifts to the individual to prove that their assets are not the product of corruption offenses. And if they cannot do so, then the assets are subject to forfeiture. But more generally, if the prosecutor can prove that any assets held by the individual are proceeds or instruments of corruption, then the court can order them forfeited and, again, repurposed. And the standard of proof that we're proposing to do this is the balance of probabilities standard, which is lower than the criminal standard of beyond a reasonable doubt. So this is the process that's often referred to as civil forfeiture, which is, again, a well-known technique across jurisdictions around the world and has a good pedigree right back to the original UN Convention on Narcotics and before. And it's yet another way to get at the tainted assets. Third, the court will have a unique ability to act as a sort of arbitrator in cases between states that deal with assets. And I want to give credit where credit is due here. This proposal came from a vision of Allan Rock's initially, and has been worked into the overall makeup of the assets division. So the idea here is that states can come to the assets division for problem resolutions. So, for example, a state might have a pot of assets that it knows are tainted, but no clear idea of what should be done with them, or no political will to act. And we've heard about money, and Martin told us about hundreds of millions of dollars sitting in bank accounts with nothing happening. So a state that's in that situation could bring an application to the assets division for an order directing what should be done with those assets. The court could hear from any other state that claimed an interest in the assets, as well as any private individuals or organizations that had some interest. And the idea is the court would be able to grant standing as broadly as needed for intervener status, for victims or other interested parties, right up potentially to party status. Another scenario would be where, say, a developing state could point to assets sitting in a bank account somewhere, say in Switzerland, and bring a proceeding to the court saying, look, those are our assets. They were corruptly taken. And the court could order Switzerland to give them back or to do something else appropriate with the assets. So it's a really powerful kind of arbitration function. Fourth, and finally, the assets division will be a clearinghouse for information and best practices, and will facilitate and actively collaborate with national agencies on the finding and recovery of assets, and of course to be interacting with other international agencies, NGOs and IGOs in the anti-corruption ecosphere. So the idea is not that of a court that sits on high, sort of remote from states and law enforcement, but rather one that's an active part of the global anti-corruption space. And there's lots more to say about this proposal, but I note that we're coming close to the end. So I'm going to cut off my remarks there and try to allow some room for questions. So thank you very much.
Thank you very much for adding that information about the division of the court that would deal with these civil issues. So that's really interesting, and I must say that I feel a little bit guilty about this panel, because as I hear the amazing information that you're all bringing to this webinar, I feel like we almost could have had a whole day on this to discuss how we pull this all together. It's been extremely rich, the information that we've heard, and I'm surprised there are a few questions in the Q&A, but maybe before I turn to those, I was just wondering, did any of the panelists want to pose any kind of a question to any of the others? I see Allan would like to. Go ahead. Put your speaker on, Allan.
Thanks, Oonagh. I'd like to ask Martin whether he resorts to class proceedings on behalf of those, if there's a large group of people who suffered loss and there's a fund that they want to recover. Do you use class proceedings, Martin?
Allan, that's an excellent question. The answer is domestically, like in the United States or Canada, class proceedings make sense against deep-pocketed companies that have done consumer frauds or securities fraud, but not so much cross national boundaries. What we find that works is the quintessential class action, the oldest version of class action, which is insolvency law. So in the example I gave you, where we act for 44 victims of €1 billion crypto fraud globally, affecting 150,000 persons, with the client's blessing, we're undertaking investigations around the world, and we've discovered 8 companies in Cyprus where the €1 billion of value stolen from all those persons was run through banks in Cyprus. Cyprus company law is modeled on English commercial or company law, meaning we can apply under just and equitable jurisdiction to appoint a liquidator over those said 8 companies. And once that liquidator's in office, he or she can act effectively on behalf of all 150,000 victims for the purpose of saying to the directors, who are the bad guys, hey, we think you've dishonestly breached your fiduciary duties over here. You have an automatic obligation under company law to account for the trust property in your hands called the company's property. It's a very simple cause of action grounded on the notion of director malfeasance. So then we can take that cause of action and use that as the foundation for freezing orders around the globe, and then have the primary trial, civil malfeasance trial in the High Court in Cyprus. As a simple example of how we might represent one day 44 people losing 18 million Australian dollars to representing the interests of 150,000 persons who've lost €1 billion. So the short answer is yes and no, but not so much in the global sphere. We like insolvency law.
Excellent, thank you.
Martin, there was a question in the chat from Barry Leon about the ICC fraud net. Could you tell us a little bit about that and possibly how it would relate to the International Court?
Sure. The largest NGO in the world of business for business is the International Chamber of Commerce, the ICC, well known in Paris in the arbitration circles. What's less well known is in London, they have a division called Commercial Crime Services Division of the ICC. Been around for a few decades. In 2004, Peter Lowe, who was a senior official at ICC Commercial Crime Services in London, came over to Dublin, Ireland, where my practice was then based, took me to dinner and invited me to be the second member of this new thing called ICC FraudNet. I said, what's that? He said, well, it's a new network we're putting together using our branding and our logo to select by invitation only the world's leading practitioners in each country of the world relevant to asset recovery to form, you know, a by invitation only esprit de corps of the leaders in this field meeting. And then I said, okay, what's your plans for growing it? He invited me to be in charge of recruitment. Today we have 96 members in 76 countries. We also have now, to sustain ourselves, because some of us are getting a little older now, we have Fraudnet Futures, where each of us are encouraged to bring an under 45-year-old lawyer to our meetings twice a year. Our next one's in Toronto, by the way, at the end of October before the IBA annual convention. And we have 170 people coming because the Fraudnet community keeps growing. We've added strategic partners, BDO, Grant Thornton in forensic accounting, a global investigation practice in New York called Mintz Group, and on and on. So we have 10 strategic partners who contribute capital to help Fraudnet operate professionally. So, and we meet twice a year, and you get disinvited from Fraudnet if you don't show up at least once in every 3 consecutive meetings. So it's a robust crew. We become friends, and we're able rapidly, it's like we call it the 24/7 rapid reaction force against fraud in the world, where we can assemble the top leaders in our field in Singapore, Hong Kong, Switzerland, Dubai, South Africa, overnight, bang, if there's a big fraud breakout and we need to free some assets fast, we have the people subject to conflict of interest checking available to run the case.
Thanks very much for that. I had a kind of general question for all of you, and if you could maybe give me your thoughts about it. In this conversation today, I heard a lot about how corruption affects so many dimensions of our lives that, you know, it can affect healthcare, as Allan was referring to. It can certainly affect environmental protection, the ability of a state to provide social programs, and politics can be very much tied up in corruption. And I'm just wondering how, what are the best methods for trying to navigate such a highly politicized zone, which, you know, as was stated by Juanita, is so extensive. You know, there's so many dimensions to the issue of corruption. So who would like to make a comment on that, perhaps? Oh, Juanita, go ahead. Thank you.
Thanks, Oonagh. Well, integration is already starting to happen. For example, the Office of the High Commissioner of Human Rights has a strategy on human rights and corruption that precisely pursues the advancing in progress in integrating both issues, which are most naturally connected, perhaps less than others, including climate change and environmental damage. The Oonagh Coalition has working groups on environmental crime, and also cross-pollinating issues, because that's true. I mean, corruption is a means to achieve other ends. Corruption is rarely an end in itself. So it doesn't help to do the hair-splitting exercise and say, oh, this is corruption, this is not corruption, this is only... The same with business and human rights. In fact, a few companies I know of are starting a trend to integrate their compliance systems, both for their human rights impacts and their integrity systems, which may have different types of regulations. But if you really believe as a company, for example, in addressing, in behaving with integrity, you put together the two issues, because you're not going to, you know, skip on one and think you're going to meet the other. So there is some progress in integration. There's also a call, for example, I've been facilitating regional meetings, helping the Office of the High Commissioner on Human Rights in the last year, facilitating regional meetings across the world. We did 4 in 4 different regions on the integration of human rights and corruption. And it was interesting to hear both from different public agencies, in both national human rights institutions and anti-corruption agencies, but also citizens and civil society groups working in one or the other issue, how they they want to work together, how they see that it makes sense, and how it would make their work more effective. So I think it's more about building than about destroying. And it's about building those connections and tolerating the complexity that dealing with the issues bring across. For example, one very interesting point for national systems, and maybe this is something that Jennifer could build on. To have national integrity, national anti-corruption strategies that are joint national integrity and human rights strategies. Why have it separately? And if you're going to have your meeting on business and human rights, for example, that would also be an interesting topic to discuss.
Thank you. Jennifer, did you want to say something?
Yeah, I'm going to take a slightly different angle from Juanita, but I do think the political dimension is something you're not going to get away from. I find it interesting right now that we sort of have an experiment happening south of the border, which I think is a reminder about why we still need to be attentive to how accountability is implemented and the guardrails. I know it always sounds like the law is the impediment to meaningful follow through on these things, but I've watched with some alarm how the rule of law is just being pushed aside. And one of the things that is common in a sort of emerging autocracy is that you accuse your political opponents of corruption. It's a very common strategy. We see the playbook coming out now, and labeling your political opponents as sort of the source of all wrongdoing. And financial wrongdoing is one of those things that sticks to you. It's hard to get rid of. So I think one of the things that I'm worried about when we talk about the politics of corruption is that there is no sort of North Star or absolute way to ensure that it's being done based on what's true or what's right. Basically, those in power get to decide what's right. And I think we always have to be really, really careful about how quickly we use these tools in circumstances where it might not always be so obvious. But that was my sort of first reaction about the political interference. Is I think we do have to realize that those with power will always seek to deploy these instruments in ways that maybe are not the best. But the second thing on human rights, I do agree with Juanita that there is a disconnect. One of the things in Canada is that we have tried, I think, inelegantly and not really consistently with the facts on the ground, tried to create a distinction between economic crime and other types of violations of the criminal law that are morally reprehensible. So, for example, a DPA is not open to you if you are involved in organized crime, gross environmental violations, gross human rights violations that involve, bodily harm and death. But to the extent that corruption can be connected to those things, I think we have built instruments around this idea that there's a sanitized sort of white collar, only paper and documents version of corruption. And we sort of pretend that the drivers behind it, which I agree with Juanita, was just in Africa recently, are multiple, and they're usually not very pretty, from trade in exotic animals to biodiversity destruction, for resource extraction and so forth. So I think we have to start maybe changing the way we talk about corruption as this sanitized, white collar crime. But when you do that, people get their guard up, and then it really becomes difficult to demand the accountability. So I don't know where the way forward is, but there are these two tensions that we have to be aware of.
Robert, did you want to add something too on this?
Yeah, we're out of time, but I'll take literally 1 minute. And I think this bounces off what Jennifer and Juanita both said. I'm a big believer in the criminal sanction. I'm a believer in the criminal law, and we need to maintain our collective sense of collective morality, and the criminal law is an expression of that morality. And I really like what Jennifer said about let's add that heavy moral dimension. But I think when we come to the table in these settings, we need to bring more thoughts and figures in, because the criminal law can't do all the work. The law can't do all the work. When we talk about anti-corruption, we need philosophers at the table, and we need sociologists at the table, and we need we need theologians at the table, because we really need a revolution of virtue in society, that you cannot legislate, right? It has to emerge from the social grassroots. So I think the conversations need to be more robust in that way.
Thanks very much for that comment, Robert. Martin or Allan, would you like to say a last word, or shall I close down at this point?
I would just like to, oh, you go ahead, Allan. I don't mean to interrupt you.
Sorry, Martin. My last word was going to be of thanks. Great discussion, terrific insights. I've learned a lot. Thank you all.
I just wanted to say a couple of things. One, Allan, I was in a Law Society of Upper Canada pre-examination course that you ran in 1990, I think, on civil procedure law in Toronto, and I enjoyed it very much. I wanted to say I join with everyone's comments about how rich and deep and thoughtful each contributor's remarks were, and it was a great pleasure to participate, and I hope we can carry on the conversation.
Yeah, that'd be great.
Thank you so much. So on behalf of everyone on this webinar, I'd like to thank you, speakers, our wonderful speakers, Jennifer Quaid, Leonardo Borlini, Martin Kenney, Juanita Olaya, Garcia, Allan Rock, and Robert Currie for providing so much useful information today. And I thank the audience for your attention and probing questions. I would just mention that we will put this on our website as a recording, so you can refer back to it. And I invite you to follow ILA Canada and ILA on our websites and social media for next events. And let's keep this conversation going about best approaches to addressing corruption around the world. So thank you so much.
Thanks,
Good night.
Oonagh.
Thanks,
Bye.
folks.
Thanks very much, everyone.
Everybody.
Bye.
evening.
Thanks, everybody.
Bye now.
Bye-bye.